People say because she's replacing a slightly left of center judge, and she's a slightly left of center judge, is not going to make much difference. And I think that's probably true in the case law. She's probably going to come down pretty much the way Souter did. Now, a lot of people say, but there's a chemistry on the court, and it changes every time there's a new member. And because she's obviously not David Souter, she has different life experiences. Who's to say over the course of the next 2 decades how she's going to interact with her colleagues? People often talked about how Thurgood Marshall, with his background and his experiences, revealed things to the other justices that they just didn't know about. And here he was a crusading African-American attorney. And so, too, everybody says that Justice Ginsburg and Justice O'Connor brought things to light that their male colleagues may not have considered. She's going to play that role, too, but the impact on decisions, who knows? There's some complaints among at least the liberals in the law school academy that her description of the judicial process was so unrealistic, so mechanical, just a process of applying the law to the facts at hand, that if Obama wants, and some people are urging him to do, to appoint a liberal jurist, someone on the left comparable to Scalia or Thomas on the right, he's a bit boxed in because his first nominee described a very, very mechanical, middle-of-the-road sort of judicial process. So that might make it more difficult. The other thing that occurs to me is this. Starting with the announcement of the nomination, all through the hearings, her supporters kept on talking about her judicial experience, more judicial experience than anyone sitting on the court at the time they came on the court, which I think is true. But there's been an undercurrent that maybe this court should not be filled with sitting judges, that its perspectives ought to be a little broader. Does that mean if Obama would want to nominate Solicitor General Kagan, for example, or Secretary Napolitano, both of whom have been discussed, Governor Granholm of Michigan, none of whom are sitting judges, are they going to push back on that and say, well, you just set the standard, was a lot of judicial experience, these people have none, how can you nominate them? That could come back to bite them also, I think. During the 19th century, up to Eisenhower, this was a very cut and dry process. Few voice votes, quick confirmation hearings. It's gotten a lot more contentious since then, and people think that has to do with the fact that the senators are before a television camera, and the hearings become less about the nominee than they do an opportunity for the senators with a fairly wide national audience to give their views on all sorts of matters that are related to the judiciary, at least in some way or other.